And now, AM 650 presents your source for leading-edge news and information on today's hottest products and services. This is Experts on Call on AM 650.
Hello and welcome to this edition of Experts on Call. It's Quay Pacific's Talk About Strata. I'm Stirling Faux, joined in studio, as always, by the Executive Director of the Condominium Homeowners Association of British Columbia and widely read condo columnist, Tony Gioventu. Hello there.
Good evening, Sterling. Here we are back in June already.
I know. It's just zooming right by. And you've brought us another guest, another lawyer, and we're going to have some very interesting conversation this time around, too. Please introduce Paul.
Well, it's a pleasure to introduce Paul Mendes. He's a lawyer with Lesperance Mendes in Vancouver, and they do a fair amount of work with strata corporations, a lot of it with conflict-oriented, a lot of it with construction and warranty work, and we're going to actually foray down conflicts in strata corporations and try and figure out how people unmess or unbind all these conflicts and figure out some of the problems they have.
All right, Paul Mendes, welcome.
Well, thank you, Sterling, and nice to meet you.
Well, it's good to have you with us. Now, conflict resolution, I guess, is going to be our theme for this hour with another legal expert in studio. Are most conflicts in most strata disputes between people, as in individuals, or is it between the strata council and individuals?
Well, I would say that even if it's between the strata council and individuals, at the heart of most strata disputes are individuals. Some of them, though, are in positions of authority within the strata, and some are not. Most commonly, though, there is an underlying personality dispute between owners.
Okay. And Tony, we have some dispute or conflict resolution mechanisms already in place in British Columbia, but there's another level coming next year, correct?
That's correct, Sterling. Right now we have for strata corporations between corporations and owners, corporations and other corporations and contractors between owners, people have a choice of opting for mediation. They can use arbitration, which is mandatory under the Act. They can go to small claims court, provincial court for things like matters that are monetary in nature under $25,000. They can go to Supreme Court for larger things that require court orders and injunctions around getting people to do things or not to do things, how they're applying with bylaws,
right,
or, those kind of things. But what we're seeing is a significant transformation in justice in British Columbia about to take place. Last year, just before the end of the term of government, what we had was the introduction of the Civil Resolution Tribunal Act. And what this is going to do is it's going to transform how we see a lot of disputes, not just for stratas, but things like domestic type disputes and small civil disputes that are monetary in nature between parties. We're going to see a lot of those things going into a tribunal system.
And so it's not just about strata. This is a new resolution device for all citizens.
It's going to really help to ease off the pressure on provincial court and even Supreme Court as far as that goes, because there are so many disputes that, they just don't kind of fit one jurisdiction or the other, so they end up going somewhere else, and they're awkward. But the difficulty with a lot of the disputes that are out there, especially strata disputes, no matter what happens at the end of the conflict, you still have to look at each other in the elevator, right?
Yeah, exactly.
And so one of the concepts of a tribunal system is it's not just about resolving the dispute. That's obviously the primary objective, but it's also about contemplating what happens after the dispute is over, right? How does this community change? Are there transformations that need to take place in relationships? How does this go on so that we don't have these people basically being constant repeat offenders in the court system, which we have now. That's one of the issues that we have with constant disputes between individuals and strata corporations.
Paul, as a lawyer, how much of your time is taken up in court versus other methods of resolving conflicts, some of which Tony has just described?
Well, I'm going to say that on the typical strata dispute, where it's, say, a bylaw enforcement matter or a dispute between owners about something, those disputes are usually resolved in the context of there being a potential court action right now.
Okay.
If someone comes to see me and says, I've got a problem, there's a damage in my unit from a water leak and the strata's not fixing it, I might write a letter to the strata pointing out why they are legally required to fix it, and then threaten at the end of it to seek instructions to commence legal proceedings.
Right. So sometimes it's the threat of court action that maybe gets the wheels turning.
Correct.
Okay.
And as any lawyer will tell you, in our court system, for every 100 claims that are filed, probably 95% or more of them never go to a hearing. So in my practice, where I'm writing those letters, typically the matters will be resolved even before I file court proceedings. So most of the disputes that I deal with are probably resolved at the letter writing stage.
And that's probably ideal, isn't it? You don't want to spend any time at all in court if you don't have to.
Absolutely. It's
Okay.
ideal in most of these situations because it's rarely the cost of proceeding legally is justified by the type of problem that we're dealing with.
Okay.
Well, the tribunal system also is going to take very much the same approach. How many things can be resolved consensually before they actually have to go to a hearing process?
Right, okay.
So there are going to be a lot of tools. There are going to be online tools to help people pre-diagnose their conflicts, to try and figure out if they've got a conflict even to start with, if they have, who may or may not be in the right. Then it goes into a kind of a counseling mediation phase between a tribunal commissioner and the parties, the people who've made the application, the people who've responded. There's a discussion, and they try to find common ground consensually within that process to find a resolution to the dispute, to put an end to it. And then at that point, if it doesn't get resolved, then the person from the tribunal who's hearing the dispute will then put it forward for a hearing formally.
Oh, okay.
And so at some point, it can go all the way through forward for a hearing, but it's going to be very economic. It will be like small claims. It will be quite inexpensive.
Do we know who these tribunal members be, who the three individuals who form the tribunal will be?
We don't know who, how many, or any of those details yet.
Okay.
Cheryl Vickers has been appointed as the chair of the tribunal at this point, acting chair of the tribunal, to basically start to implement the rules and to bring all the committees together. There are a structure of committees that are set up across the province to consult with the different types of disputes. There's Strata. There will be motor vehicle type disputes.
Oh, okay.
There'll be civil disputes. There'll be a variety of types of things. Insurance type disputes. The consultation process and and basically the development, the rules and regulations are underway now. Also, the development of all the online tools. So rather than people going in blind to disputes, they're going to have to actually go in on a website. They're going to actually have to populate all their information about the dispute on the website. So when people actually get involved, they're starting fresh,
Right.
From a real point.
And all of this is coming into effect when again? Next year sometime?
Well, it's going to be about time when the rules and the regulations actually get
Okay.
implemented. They get some test runs, when all the websites get set up. So nobody can commit to an actual time yet. Projection is late 2014 for some of the tribunal stuff.
Okay.
To possibly be up and running by then. But there's all kinds of variables that could delay that.
So anywhere from a year and a half to 2 years away, this tribunal should by 2 years from now, be up and running for all intents and purposes.
And the government is fully behind supporting it, moving it forward at this point, because the anticipation is it will relieve a lot of pressure off the court system,
Yeah.
and it will actually find another way of resolving these issues.
Well, thanks to Tony, friends, we have, and thanks to you and your contributions, we have a whole lot of email scenarios that have come in over the past while. And Paul, it's so nice to have a lawyer in the studio again, because we've got a few scenarios that Tony has lifted from his voluminous quantity of emails, and let's just go through a few. You're the lawyer, you've sat in, and Tony, you've sat in on Strata Council advising the people on how these things go. So here we go. An owner lives in number 101. Above that owner, in 201, they have kids who run around and make a lot of noise. The owner files a complaint. The Strata Council advises, hey, this is a normal part of living in a strata, and we're not going to do anything about it. So, Paul, what are the options for dispute resolution for the guy below the family with the noisy kids?
Well, this situation arises quite often. Sometimes it might be noisy kids. Sometimes it could be piano playing, stereos, whatever. And a common approach taken by Stratas is to say this is simply a dispute between neighbors. So what I always recommend to people at first is, have you gone and spoken to the owner upstairs after you've made this complaint and the council has determined that it's not a bylaw infraction matter? If a person's comfortable in doing that, I always recommend that as a first step, and effectively what I would call an informal or almost self-help type approach to dispute
Head them off
resolution.
at the pass conversation, huh?
Head them off at the pass.
Okay.
And sometimes that can work, and sometimes it doesn't. Now, if it doesn't work, then your next question is going to be, what remedies do I have under the current legislation to deal with this? And your options are going to be, under the bylaws, you have voluntary dispute resolution. Most bylaws will have that as one possibility. Again, it requires both sides to agree
They
to
have to agree, sure,
participate.
right, yeah.
Then you have arbitration as one possibility under the Act, and of course court action. And hopefully before you've done that, you may, depending on the type of the problem that it is, get some legal advice as to which of those is the best option.
Now, you said in a previous conversation that a lot of what you do involves essentially threatening. You're pointing out legal realities, and if you fail to comply with this legal reality, we may be moved at some future date to go to court over this because it's your services are required here. It says so in the law. Yeah. So how would you take the person enduring the noisy family above him or her? How do you get those two people together in such a way as everybody walks away happy? Let's assume the individual in 101 down below has gone up and knocked on the door and said, your kids run around, they make a racket, and it's it's upsetting. Is there anything that we can do or you can do to kind of tone it down a little bit? And for his troubles, bam! Don't you talk about my kids like that. The door gets slammed in his face, buzz off. And that's the end of that attempt. So what's next? What do you do next?
Well, we're going to assume in this scenario that the noise is excessive and that it actually constitutes a nuisance and contravenes the bylaws, because there is an issue often with noise as to whether it is a nuisance or not. So for the purpose of this scenario, I'll assume that it is.
It is noteworthy and
It is
noisy.
noteworthy and excessive.
Okay.
So I think the first step is going to be to write to the Strata and point out that they have an obligation under the Act to investigate and enforce the bylaws. It's not enough for a council to say this is a matter between owners and they should resolve it amongst themselves.
It's a normal part of living in a strata. That was their response.
That was their response.
Right.
And that would be an appropriate response if they had determined that investigated and determined that the noise was not excessive. But we're assuming in this scenario that the noise is excessive.
Okay.
Then I think the Strata Corporation has an obligation legally to enforce the bylaws, and I would point that out to them, that they have that obligation. Now, if that letter that said you've got an obligation to enforce the bylaws didn't achieve a desired result, which might be the Strata enforcing the bylaws by perhaps fining the owner that's making the excessive noise, then I would be recommending to the owner in 101, now you've got two choices. Really, you have arbitration as one possibility, litigation as the other. And the litigation would not really be between the two owners. It would be between 101 and the Strata
Council
on the basis that the Strata is not fulfilling its duties under the Act and enforcing the bylaws. You might name 201 as a party in those proceedings, but for certain, the main parties would be 101 and the Strata Corporation.
Interesting stuff.
I would probably not recommend arbitration. And I'd be curious to know what Tony's experience is with this, but generally speaking, I don't come across a lot of cases that are arbitrated, and one of the main reasons for that is, contrary to popular belief, it can actually be more expensive than
going
litigation.
to court?
Yes.
Really, huh? Because it can become protracted. It can go on and on and on.
Certainly, and also you pay for the
judge. And
judge.
court doesn't go on and on, does it?
It does go on and on, but for different reasons.
Okay.
But in arbitration, it's private judge, and you're paying the cost of that judge, splitting it 50-50 with the other side.
Okay.
So in some cases, some of the people that do this, some of them are ex-judges who charge in the hundreds of dollars an hour.
Yeah.
And so, just to get out the gate and commit to having this person hear your arbitration, you've got to come up with $2,500 or $5,000.
So in this particular instance, you would recommend against arbitration and go directly to just leapfrog that and go right to court.
Right to court.
Tony, what would your advice be to the person in 101?
It's an interesting thing when we look at strata disputes, because I think that, I look at our offices and all the calls that we get. There are, it's nice to see that the transition is now probably about 75% of them are some sort of trouble or conflict, but the other 25% are really now about planning proactively. So we're starting to see a bit of a change on how stratas are behaving. But it's like it's like an onion. Strata disputes are kind of like an onion.
Right.
Keep peeling these layers away and you keep finding more and more information, which is one of the problems with arbitration. Because as they start to get into the dispute and they start pulling all the bits and pieces apart, more issues become dragged in. An example could be the Strata Council. This is a wood frame building. The Strata Council allowed 201 to remove their carpets and put hardwood floors and gave permission for it. What if that happened?
And with the little kids thundering around, it just amplifies even more.
Even more, right? And wood frame buildings aren't designed for that. They're designed for carpet as an essential part of the soundproofing. So, when we're looking at the disputes, it's, I find our work on the front end is always to gather as much information as possible and try and figure out, and there may be a history. There might be some sort of history between these two people, that this is just a symptom of that history, right?
Exactly.
There could be other things. It could be, as Paul said, quite reasonable with respects to the dispute. But if it's comes right down to the fact that it's unreasonable noise and the Strata Council really wants a decision, or the owner really wants a decision or wants council to do something, your quickest step is just to get into court to get an injunction. Get the courts to order the council to enforce the bylaws.
Right. Need to take a break here. Conflict resolution, one of the themes of our program on this edition of Key Pacific's Talk About Strata. Delighted to have Paul Mendes, Strata lawyer from Lesperance Mendes in Vancouver, with us. He's Tony Gioventu. I'm Stirling Faux, and we'll be right back.
Delivering relevant and beneficial consumer information. This is Experts on Call, and there's more still ahead on AM 650.